Crivello, the All-Pak machinery system.
Thank you. Mr. Kenny?
Morning, Your Honor. Madam Chief Justice, Associate Justices, my name is Paul Kenny. Represent the plaintiff appellant, With me is Richard Chambers, who also represents. We were not trial counsel in this particular case, and the plaintiffs filed an appeal after which we were retained to proceed. In the facts of this case, Your Honor, involve immigrants, husband and wife who are immigrants and do not speak, read, or write English, and speak their native tongue of Italian. Now, with regard to the speaking, they understand some language, but they have difficulty understanding the English language. At some point in time, while working for Crivello, a company that used a bagging machine to bag T-shirts, by heating the T-shirts would be put in plastic. They would then be placed in this machine where the hands of the operator, who was Mrs. Crivello, would be very close to the machine. A heated element was passed, and the machine would close, and the bag would be heated, melted, and the product taken away, and she would repeat the process. While operating this device, her hand became caught in the device, which had no warnings, and she had been schooled, or if you will, or taught how to operate this by the company. And the person who taught her testified later on that she was the person that had trained Mrs. Crivello. Oddly enough, and appellees rely on this, she stated that Mrs. Crivello had no problem understanding her when they spoke in English. And they cited this in their brief, and it's located on, I believe it's Appendix 4, page 384, where she said, I had no problem communicating with her. Well, communicating, when she testified, didn't mean that she had no problem speaking with her. What she had was no trouble communicating, because when Mrs. Crivello didn't understand, she would explain it in a different way, and then she would explain it again in a different way, and finally she would show her how to do it.
Did you file the motion for new trial?
A motion for new trial was filed by trial counsel.
Is there, I don't know the record well enough, is there an affidavit from Ms. Crivello under oath, under penalties of perjury, in that that motion saying she doesn't understand, can't speak English and all that stuff?
No, but it's contained throughout her testimony. It was not with regard to that. And her testimony, I don't speak English very well, and the court itself noticed that...
So nowhere in the record do we have anything sworn to under the penalties of perjury by her that she has difficulty communicating verbally in English.
I believe we do in her testimony, Your Honor. There was no affidavit filed, but I believe her testimony specifically says, I have trouble understanding English.
How many days did she testify for?
She testified for, well, I think it was 2.5 days, Your Honor, but I believe there were half days, really.
Yeah. Direct exam, cross-exam?
Direct exam, cross-exam.
So we'll look at the record, we'll see that she answered all the questions.
She answered the questions, Your Honor. Well, she didn't answer all the questions. Some of the questions she couldn't answer. If a look at the record will indicate that this was a proud woman who had come to this country and would not admit she had not. On her direct testimony, there were key words where she, in fact, answered the questions. However, there is no question this woman couldn't read and write English. And if we look at
nobody thought after the fact to file together with the motion for new trial to, A, file an affidavit, you've already told me that, but to get to bring the issue to Judge Whitehead's attention, so he perhaps could have said what I think he would have said that this woman had no difficulty testifying. No one brought this to his attention, did they?
Actually, Your Honor, Judge Whitehead specifically said that I don't understand what this woman has been saying. It's very confusing. And at that point, even if he believed she could understand English before that, that would have prompted the statute to become effective.
Well, Mr. Kenny, what's the rule that you want us to have in future cases? When is a judge to, even without a request from a party for an interpreter, when should a judge provide one?
I think a judge should provide an interpreter when there's a question as to whether or not this person speaks English.
When there's a question for the judge?
For the judge, yes, Your Honor.
Even though no one asked for it?
That's correct, Your Honor. I think the statute fairly says that the party or the attorney can't waive that right, and the statute specifically says it has to be broadly construed.
Mr. Kenny, I understand that. Here's I think what Justice Ireland is getting at. Neither she nor her counsel requested an interpreter, correct?
That's correct, Your Honor.
And there was certainly no reason why her counsel couldn't do that.
That's correct, Your Honor.
And this is not, the waiver question is not where the judge turns to the lawyer and says, you know, now Attorney X representing Ms. Crivello, don't you think your client should have the assistance of an interpreter? And the lawyer then consults and he says, no, we're comfortable going, you know, that, then you're into waiver. Nobody's claiming here that she waived. The question is, particularly where she's represented by counsel, when counsel doesn't request, where much of the testimony is oral, the testimony is oral, much of the evidence is oral, correct?
Actually, no, Your Honor. Much of the testimony, especially in cross-examination, was based upon cross-examination of the written record, the hospital records, documents she had signed, and there was no question she couldn't read or write English, even if we were to assume that there might be a question as to how much she understood
So
speaking.
she could read and write.
She could not read and write, and she was questioned in cross-examination with those documents, which there is no question she couldn't read and said so.
Did her attorney object then?
The attorney, no.
Did her counsel object? Here's the concern that I have, which I think underlies Justice Ireland's question. She's a party who's represented by counsel.
Yes, she is.
And part of what a lawyer does is to make the lawyer knows the client. And if the lawyer doesn't say, look, my client, I mean, I'd have to look at the transcript, but if the lawyer says she can't read or write English, we'll have to read it for her. That's one thing, correct?
That's correct, Your Honor.
That presumably wasn't done here.
There was nowhere in the record that I can determine that was done, Your Honor, other than there was representations made by counsel that in answering these questions, particularly in cross, that she was to the left or to the right of what the questions were, indicating a inability to specifically understand, although counsel would have been...
She had had her deposition taken, correct?
Yes, she did.
And at the deposition, was she questioned about documents?
I would assume she was, Your Honor, but I was not present at the deposition.
No, but I mean, you must have looked at the discovery. I mean, if the discovery was available.
I did not have the deposition.
I mean, you understand the problem that we're dealing with is when the proceeding is going on, there are many people in this Commonwealth for whom English is not their primary language. they may have different levels of ability to speak. Many people understand, but they can't reply in English. Many people can talk in English, but they are less comfortable with reading. Many people can read, but they couldn't summarize. I mean, there are a variety of things. And if the client is represented by a lawyer, and the lawyer is essentially what you're asking us to do is impose on trial judges that they should, in a case where somebody is represented by a lawyer, on their own have a kind of inquiry as to how much the witness. Now, maybe that's what the statute requires, but isn't that what you're asking this court to hold?
Yes, Your Honor. We believe that's what the statute says, but it's more than just what she might say to a specific question or an answer. The statute requires to have an interpreter during the whole trial. We had a 3-week trial here with numerous documents which she couldn't read or write.
Is it clear that the judge knew that she could not read English?
Yes, it is, Your Honor. It's clear from the testimony that she could not read or write. She testified to that. Her husband
Was she required to write anything?
No, Your Honor.
Okay, so let's leave out the right. Okay?
Excuse me, she was, Your Honor. She was required to sign documents and...
at trial?
No, not at... Oh, I'm sorry, Your Honor. I misunderstood the question. Not at trial. She wasn't required to read... to write at trial.
If the claim is when she signed something, she wasn't able to read it, that's not a problem that the court can correct.
No, Your Honor.
What do you do when the judge makes an observation that she understood and articulated much better on direct exam than on cross-exam?
I think that's clearly explainable, Your Honor, by virtue of her attorneys preparing her for trial. If you look at the questions that were asked, they contained words that she could have related to.
Well, frankly, that goes against you. What do you do with Ms. Salufo, her supervisor, who says that Ms. Crivello had no problem speaking English?
Well, Ms. Salufo basically said I had no problem communicating with her.
In English?
Yes. The problem is when she went on, her next questions were, how did you do that? When I asked her a question, Your Honor, she said if she didn't understand it, she would say, I don't understand it. And then she said there are a couple of cases where she had problems understanding. She said, yes, there were. What would you do? I would show her how to do it.
Okay, because we're dealing not with the part of the statute that says she cannot speak English. That's clearly not involved here.
That's why I was
We're dealing with the part of the statute that says difficulty in speaking. And
that's correct, Your Honor.
We've got to determine to what extent she had that difficulty.
That's correct.
Well, go ahead.
I'm sorry.
No,
I think the statute goes along to say, in that event, where there's a difficulty speaking, the court is required to hold a hearing to determine whether or not she can.
And
they can't infer that.
And I say it depends on what this transcript shows. And if this shows a muddy situation with the judge making the kind of observations he made and the supervisor talking about she could understand English, then you got a little problem here. Particularly if her answers on direct exam are clear, responsive, lucid, and so forth.
Well, as I indicated, she would have been prepared for that. However, you would have some of the same kind of answers that, while they may appear to be lucid from a strict English standpoint, they're not responsive. They don't address the question, so she doesn't understand the question, whereas an interpreter would have allowed that. In addition, Your Honor,
Mr. Kinney, again, I mean, I think we're all beating about this. The statute talks in terms of speaking or understanding. One way to interpret that is not written. That is to say, it's speaking, the flip side of, or being spoken to, or understanding when I'm speaking to you. Please, I'm not a linguist, and I don't think there's evidence in the record, but frequently people can read English but have difficulty speaking it and difficulty, particularly when it's spoken at them. It's much easier to read than it is to speak and understand. So it's not entirely clear to me if you say that she could speak, she could understand. The fact that she was less certain when she was being cross-examined is not unusual. People whose native tongue is English are less certain when they're being cross-examined. But I'm not even sure if the statute says anything about reading English.
The question, Your Honor, whether or not the statute says anything about reading, when
Correct.
she was questioned on cross-examination, she was asked to read this document. Isn't this a document you signed? She has no idea. She's been required to do that. Plus, when other people are testifying and other things are happening, she has a right to understand what is being done in order to participate in her defense.
I understand, but the statute goes on to say because he uses only or primarily a spoken language other than English. So my first threshold is, you focused a lot on the writing piece, that she didn't understand when she's shown the writing. So first of all, I'm not even sure if the statute covers that. And then I've got, she can speak on direct. Yes, I understand she may have been prepped for her testimony. That's perfectly fine. But that, people are a little bit more hesitant when they are being questioned. But the judge could observe and ask the cross-examining attorney to speak more slowly, to make sure that she understood. I take it, if we look at this, the thrust of the problem will be with she was asked to read and then was asked questions about that.
That was part of it. However, she was also assumed that she was going to learn, but the court at a point said, we don't understand what she was saying.
Well, that's different.
Yes, Your Honor. So if the court doesn't understand what she's saying.
And the court asked her to repeat her testimony?
No, the court just went along with regard to that.
Well, what we'll have to do, Mr. Kennedy, is to
Pardon me, Your Honor?
I said what we will have to do is to look very carefully at the transcript here, which we will do, obviously. Thank you, Mr. Kennedy.
Thank you, Your Honor.
Mr. McDonough?
Thank you, Madam Chief Justice. May it please the Court, my name is Miles McDonough. I represent the defendant appellee, Pacemaker, and with me is Nicholas Grimaldi, who represents All-Pak. Your Honors, in light of the Court's questioning, I do want to underscore a little bit of the findings that the trial court made with regard to the use of language by the plaintiff. In the contempt findings, the trial court specifically found that the plaintiff had, in a designed fashion and in a conscious fashion, used the English language to make those remarks that were the subject of the contempt order. The trial court described the plaintiff as well-informed, intelligent, alert, engaged, specifically found that she understood the warnings that were given, obviously, in English. The other circumstances surrounding the surrounding circumstances that the judge would have had in mind were, among other things, as Justice Greene alluded to, the plaintiff had testified in English for some 3 days or so. There was evidence that she spoke English on the job. There was evidence that she ran a real estate business. There was evidence that during a cross-examination, there was an interesting exchange where 4 times she denied in English, she answered no, or denials essentially, with regard to questions that were essentially 180 degrees from questions that were put to her on direct examination concerning a prior injury that was the subject of a DIA claim.
Do I take it, Mr. McDonough, that obviously the statute codifies what this court has always strongly supported, which is in any context you want people to understand proceedings if they are participants in the proceedings, correct?
I would say that the court, the statute, strictly speaking, is a codification which in part but not entirely displaces the prior common law of discretion with regard to the trial court. There is a limited displacement.
Particularly with respect to oral.
Yes, Your Honor.
Okay.
And by the way,
And so I take it that what this judge did, notwithstanding the fact that there wasn't a specific objection, was to actually observe that there might have been a linguistic difficulty and to actually make findings with respect to those linguistic difficulties. Am I correct?
I think that is, yes, Your Honor, I think so. And whatever limited limitations there might have been, as a matter of fact, plaintiff's counsel, there was a plaintiff's counsel here made reference to the plaintiff's counsel's remark in the lower court to the effect that on some questions there were answers a little to the left or a little to the right. Well, show me a trial where that doesn't happen in whatever language it's conducted in.
You mentioned something about she ran a real estate business. Is there evidence about that in the record?
There is, Your Honor.
And what kind of real estate
A
business?
real estate trust, 40 apartments, 8 or 9 buildings.
And what was her, in what capacity?
They were
No, what was her capacity in the business?
She dealt with there were tenant buildings, and she did whatever management there was in association with those buildings.
Was there
including going to housing court, I believe.
Was there any suggestion that her operation of that business was done in a language other than English?
No. She was also in the country for 33 years before trial. There was evidence to the effect that she spoke with doctors in English. There were verbatim quotations on reports, etc., in English. Plaintiff's counsel stated to the trial judge in the trial proceedings, nobody's suggesting she didn't understand. Let me turn them from the factual findings and the evidence that was before the judge and make a few points, because this is a case of first impression in the sense that the court hasn't had occasion to address Chapter 221C before. I'd like to underscore a few procedural points here. First, we sent you a rule. I sent to the court a Rule 16 letter.
I saw that, but
all right.
Okay. You mean the one yesterday or the day before?
Yes, Your Honor.
I mean, it's fine to send it. Not really helpful to me, because we want to have proceedings where people really understand what's going on. And
yes,
if it was clear from the record that somebody absolutely didn't understand what was going on, there were no findings by the judge, and the person were not represented by counsel, we may have a problem. So,
I understand,
okay.
Your Honor. Let me just mention that there is the waiver issue presented by the Unitherm case. There is also, on this court's prior jurisprudence, this court's present jurisprudence, I guess I should say, which doesn't go quite as far as the Supreme Court just yet, on omissions in Rule 59 proceedings, which, by the way, is exactly what we have here. There is no mention whatsoever of Chapter 221C.
Yeah. Can I just ask you on the waiver question?
Yes, Your Honor.
We don't have to get to waiver, because don't we have a slight problem? Or do you think the judges, I mean, we don't even have to get to 221C Section 3, do we? Yeah? I mean, that you've got to have a proof by judge only after the non-English speaking has consulted the time explained to through an interpreter. I mean, I mean, you're talking about not the waiver of her right to
No, I'm sorry. Let me clarify. I'm talking
Thank
about
you.
waiver in the good old-fashioned you didn't raise it below sense.
Okay.
In other words, there's a distinction between whatever the non-waiver rules in Chapter 221C say, whatever their impact is, it begins no earlier than opening statements, and it ends no later than the jury verdict.
Okay.
It's designed toward, as Your Honor has indicated, toward oral evidence. So it has nothing to do with writings. Rule 59 motions for new trial are writings, and it has nothing to do with what happens after the trial proceedings are adjourned. On Volume 5, page 418, I think it says, the proceedings are adjourned, and that's right after the jury verdict was entered. So the statute is inapplicable here. It also, with regard to prejudice, though, Your Honor, under this Court's current jurisprudence, this Court has always found it appropriate to find waiver where there's an omission under Rule 59 filing, where there's potential prejudice to the other side. Here, if you really think about it, what the trial judges are called upon to do with regard to whether or not an interpreter should be appointed is a time-sensitive exercise. It's not the same. People's abilities, their psychiatric conditions evolve over time. Their socialization evolves over time. Whether they're involved in businesses evolves over time. Their communication abilities evolve over time. So this is a prime example of where there would be prejudice because circumstances would have changed 3, 4, 5 years after a case is tried after appeal in terms of trying to take another snapshot of where that person was way back when. So I would submit to you that's a legal argument that there's prejudice which would...
I think what might be helpful, Mr. McDonough, not so much this case, is what triggers any obligation during the course of trial?
Your Honor, let me propose this.
We have many people for whom English is not their native tongue, and yet there's no, it seems to me, no requirement that every single person for whom English is not their native tongue automatically have an interpreter.
Your Honor, I think of a radar screen, and I'll return to that in just a moment.
Okay.
But I would point out that this statute, 221C, does not do what other jurisdictions have done. It does not have a presumption. Like New Jersey, I believe, may have a presumption of use of an interpreter. As I say, I think of a radar screen in terms of trying to put myself into the shoes of a trial lawyer. If it were the rule under 221C that every single witness and every single party, and by extension it would have to be every single juror, if you buy the plaintiff's interpretation of the statute, would have to undergo...
No, we're not going to do that.
No, okay, but as the alternative then, Your Honor, the alternative gets me back to the point of preservation of some of the judge's common law right of discretion. If you think of that radar screen, and you think of everybody potentially involved with the case being at the outer edges, if you will, the trial judge, you know, as somebody comes in and shows confusion, shows perhaps a person has a foreign accent, foreign sounding accent, and there's some other indication that the person may speak a different language more frequently than English. As that evidence or information comes to the judge, the blip, if you will, gets a little closer to the center and beeps a little louder, or whatever it is radar screens do. There is that moment where the judge is going to say to him or herself, I will be doing something a little bit differently now from the traditional role of judges. I am now not just going to be listening to evidence and making rulings on objections and doing all the other things judges have to do during trial. I've got a little something else here to think about. I've got to be a little bit proactive. At some point where that judge makes that determination, that's discretion. That's an exercise in discretion, Your Honor, because if you don't go with the rule of discretion, it's impossible. Right.
So I take it that you would not cavil with the First Circuit's decision, which essentially says, don't ask the appellate courts to do that, because you've got to actually, the transcript isn't going to tell you much. Leave the discretion, but, you know, give some guidance. And what the First Circuit says was significant language difficulty. Right?
Yes, Your Honor. I believe the carry-on case, or maybe I'm...
Yeah.
I think that, but I think that imputes discretion.
Of course.
Well,
it's quite explicitly imputing discretion. It will be fruitless and frustrating exercise for the appellate court to do it, because you can't tell from a black and white transcript.
And, Your Honor, I think that to come full circle, again, it's a straight-up Rule 59 procedural case, but those same underlying rationales are what underlies the Unitherm case, which the Supreme Court just came down with. You can't replace what the court calls the input, or the other word they used was feel, of the trial judge who makes the observations of the witnesses and the totality of the circumstances at trial. Your Honor, I see my time is up. Unless there are any further questions, I think we'll have to rely upon the briefs.
Thank you, Mr. McDonough.
Right, thank you, Your Honor.
Ms. Grimaldi? Mr. McGrimaldi, I'm so sorry.
May it please the Court, Nick Grimaldi for the appellee All-Pak Machinery Systems. Mr. McDonough has done, I think, an excellent job discussing the appellate issue that involves the interpreter statute. What I'd like to do very briefly in the time I have left, although it wasn't argued by my brother appellant, is talk very briefly about the issues other than the interpreter statute.
They're all discretionary rulings, are they not?
And there's ample evidence in the transcripts that the judge not only exercised the discretion, but did it with sound basis. The demonstration of the machine was given a cautionary instruction that...
When did you first inform the plaintiff that you would be demonstrating the machine?
Well, there's evidence in the transcript that it was not listed as an exhibit. I also don't believe it was admitted as a full exhibit. So it was something that was reserved and wasn't disclosed as being definitely going to be used until the day that it was. On the other hand, this is a products liability case involving a design defect, and there really is no surprise that can be had by the demonstration of the very product at issue. There was no allegation here that the product had been modified in some way that caused the injury. The issue here was that the safety features were not adequately designed. The plaintiff's expert, in fact, inspected the real, actual machine that caused the injury, and the plaintiff's expert testified. The plaintiff's expert also had an opportunity to review, and there's some discussion of this in the record, a videotape demonstration that was going to be introduced alternatively, which was then withdrawn when the judge allowed this demonstration. I don't mean to interrupt you. The actual machine at issue, there's a lot in the brief about this being the wrong machine and being incapable of causing injury. In fact, the actual machine was gone by the time that these defendants were sued.
All discretionary. If the judge decides the machine is helpful to the jury, whether it's the same machine or not, and if it's similar, he can allow it.
There was evidence that it was substantially similar. On the issue of prior incidents, Your Honors, there was 3 separate opportunities where the plaintiff could have made an offer of proof that these alleged prior incidents should have been admitted, meaning they met the standard to be admitted as evidence, and the record will show that they did not do that. For these reasons, I believe the other 2 main issues on appeal should not be disturbed by this court. Thank you.
Thank you, Mr. Grimaldi.